Our next speaker is David Heliac, who will discuss domestic violence restraining orders and criminal equity. David is an attorney and an independent scholar in New Jersey whose published articles include the New Star Chamber, the New Jersey Family Court, and the Prevention of Domestic Violence Act, and erring on the side of hidden harm, the granting of domestic violence restraining orders. In 2022, he received an LLM in International Legal Studies from Liberty School of Law. His most recent article on the topic of domestic violence restraining orders, Shuttering the New Star Chamber, toward a populist strategy against criminal equity in family court, can be found online at the Liberty University Law Review website. Please welcome David Heliac.
Good evening. Domestic violence restraining orders go by many other names, such as orders of protection or protective orders. I'm just going to use the term restraining orders. In America, the rates of domestic violence committed against men and women are roughly the same. Indeed, the CDC found in a 2010 survey that men were actually more often the victim of domestic violence than women were in the preceding 12-month period. Nevertheless, domestic violence restraining orders are overwhelmingly issued against men, which makes them a suitable topic for International Men's Day. This evening, I'd like to go over 1, the denial of due process to restraining order defendants, as well as 2, criminal equity, also known as government by injunction. As I'll explain, these go hand in hand. In my opinion, the most important due process protection that is denied restraining order defendants is the right to a jury trial. Judges are under a tremendous amount of pressure to grant restraining orders. If they were to not deny one and something headline grabbing happened soon thereafter, they'd be blamed. Last year, in United States versus Rahimi, the Fifth Circuit ruled that it was unconstitutional for the government to deprive someone subject to restraining orders of their firearms. In his concurrence, Judge Ho made note of due process issues concerning restraining orders. For example, he noted the tremendous pressure that judges are under to grant them. The case went up to the United States Supreme Court and the Fifth Circuit was reversed. In deciding it, the Supreme Court made it a point to avoid the issue of due process. This means the issue is still open. In light of Judge Ho's recent recognition that restraining orders may have a due process problem, I believe the time to attack restraining order statutes is now. I'd therefore like to briefly go over what I believe is a powerful argument against restraining orders, which is that they constitute criminal equity, aka government by injunction. Criminal equity and government by injunction is shorthand for saying a practice is unconstitutional because it entails a criminal matter being handled by an equity court. Or put another way, it entails the government handling crimes through the use of injunctions. Restraining orders are typically issued by family courts, which are equity courts. For the non-lawyers present, what I believe is the critical distinction between equity courts and other courts is that equity courts grant injunctions. An injunction is an order issued by a judge directing someone to either do something or refrain from doing something. In contrast to equity courts, in regular civil courts, you only get to sue for money. In criminal courts, because liberty is so important, defendants are given many due process protections. So in addition to jury, which I just mentioned, there's a higher standard of proof than in the civil court. There's often a right to a free attorney. And in contrast to what I've seen in restraining order hearings, there's a full evidentiary hearing, not just a summary hearing. The power of injunctions come from the power of the court to find defendants in contempt for violating an injunction and then punish them. Restraining orders are injunctions. Restraining order statutes differ from state to state, but typically the way they work is that a family court judge is called upon to find that an act of domestic violence occurred and that there's a risk that the alleged victim might suffer further abuse. The judge will usually then issue an order with various provisions, including the provision that the abuser cannot go near the victim and cannot commit any further abuse. These orders can have devastating effects on defendants. Most notably, if he's a father, it can affect his ability to participate in the life of his child. Dad is thrown out of the house. Often he's restricted to supervised visitation. Sometimes he's forced to undergo counseling before he can see his kid. It's often a living nightmare. Now, this is the part I'm interested in. Around the turn of the last century, meaning 1900 or 2000, criminal equity was actually a hot topic. In 1896, the Democrats actually had a statement against government by injunction in its national platform. Many law review articles from this time period criticized the practice and often made reference to the Star Chamber. I don't know if anyone's heard of the Star Chamber, but it was a court of criminal equity that originated in England in the late 1400s and served as an alternative to the regular criminal courts. It was named for the stars painted on the ceiling of the room in which the cases were tried. It was shut down in the 1600s and became synonymous with unfair courts, like how we say kangaroo court today. Around 1900, there were two main areas in which government by injunction was practiced: labor disputes and vice. In the case of labor disputes, if an employer caught wind that a strike was about to happen, he would go to equity court and he would get an injunction against the strike. And then if the strikers committed a crime in the course of their strike, they were hauled back to the equity court judge and they were punished. It was a way to circumvent normal due process given to defendants. Labor activists were ultimately successful in getting legislation passed that put an end to the practice. The most important example of this is the North LaGuardia Act, passed in 1932. But while labor was victorious, the peddlers of vice were not. So once upon a time in America, cities had red light districts like they do today in Europe. There were places well known by locals where people could go to partake in illegal vices such as prostitution, gambling, or illegal alcohol. Moral crusaders were able to get laws passed that shut these places down through the use of injunctions. My favorite case is Hedden versus Hand, a New Jersey decision from 1919 that struck down an anti-vice law for being criminal equity, though it didn't use the term. With Hedden, though, New Jersey was the only state to find this type of law unconstitutional. In other words, in the area of vice, the promoters of government by injunction won. In both areas, vice and labor, the fight over government injunction ended about 100 years ago. And I believe as time passed, the concept slipped from the public mind. And now with restraining order statutes, government by injunction is back with a vengeance. Drawing upon America's traditional hostility to criminal equity, going back to England's bad experience with the Star Chamber, strong legal arguments could be crafted against the different statutes. I believe it's now time to dust off the government by injunction critique found in old cases and old law review articles and bring it forward. Different states have different restraining order schemes and different case law, so the arguments would have to be customized. But I could see all of them contending that the statute at issue has created a new Star Chamber. I very much encourage this. Labor did it, so can dads. Thank you.
I have a question for David. You talked about restraining orders and star chambers. What is your proposed solution to restraining orders and the restraining order issue? Or are you of the belief that they should be canceled permanently, forever, always, or is there a different solution?
All right. Well, I have thought about it. It's a conundrum, to be honest. I mean, my gut reaction is to get rid of them and then have rigorous police, the regular criminal court, just prosecutors really crack down on domestic violence, really prosecute them, punish real abusers hard, and put an end that way. I've been playing around with the idea of getting rid of the DV statutes, but allowing judges to grant injunctions to protect to some degree. But these would have to be crafted and case by case customized, as opposed to what we have now, which is a cookie cutter approach, and like tremendous political pressure to just throw data out of the house and just pile on, right? I think that's fair to say. And if you get rid of the politicization of it, some kind of injunctive relief might not be a bad thing. And in fact, before these domestic violence statutes were implemented, it was very rare for judges to grant injunctions for violence because there was this view that you can protect property with injunctions, but not personal bodily well-being, integrity. And maybe had they been a little bit more flexible, the impetus for these DV statutes wouldn't have been so great.
Can I do a follow-up question?
Yeah.
Go ahead.
What do you think about this idea, pros and cons? If there's a restraining order by parent A versus parent B or husband A versus wife, what if they went both ways automatically? Because if somebody is a victim and they want the other person away from them, you don't want that alleged victim to abuse that order and incriminate the other person intentionally. But there should also be no reason for the victim to want to be near the alleged criminal. So what if you made restraining orders go both ways instantly on day one? Is that an option? Or is that a bad option?
Did you guys hear that online?
Yes.
Give me a thumbs up. Yeah, good, thanks.
So what my general theme is that these injunctions are basically bad because they then allow further problems. So dad's enjoined from doing X, Y, Z, and then he can be hauled back into court and says, you did X, Y, Z, or you did X or Y, or, and it's maybe dubious, but now you've got another summer hearing and it's another way to just keep adding to the stress. It's more gamesmanship. Like I think it's fair to say that these restraining orders are often requested as part of an openings move in a divorce. And then when they're there, they can be used again. Like I really don't want dad seeing the kid as much. I'm going to say he violated the restraining order. That's going to throw some chaos into the mix, and then dad won't see the kid until they like sort that out. It's like an alienating tool. So I generally don't like injunctions. If you're going to have them, they should be more case by case crafted, like injunctions are supposed to be. That's what equity court's supposed to do, like create a case by case customized solution.
Thank you.
Thank you.